Okay, great. Well, thank you everyone who is joining us live and those joining us on the recording after the event. So I'd like to introduce James Grimmelmann, who is the Tessler Family Professor of Digital and Information Law at Cornell Tech and Cornell Law School. He's also an IC3 faculty member. He studies how laws regulating software affect freedom, wealth, and power, and he works to help lawyers and technologists understand each other. So thank you for joining us, and I'll turn it over to James.
Thank you, Sarah, and thank you all for being here today. And so I want to give kind of a lawyer's perspective on blockchain. And by that, I don't mean a lawyer's perspective on the legalities of initial coin offerings or on AML compliance. I mean more of a law professor's take, and I teach property law in particular. So I'm thinking about how do you fit blockchains and the apps they enable into a well-established framework of law in a way that doesn't do violence to either the blockchain or the law. And so today I want to draw on some really powerful ideas that a scholar named Carol Rose developed in an article called Crystals and Mud in Property Law. So I'm going to talk about crystals and mud on the blockchain. And in order to explain what she means by crystals and mud, I have to motivate some of the problems that property law has historically tried to solve. So I'm going to tell a story from the history of property law, step back and give Rose's perspective on it, then apply some of those ideas to the blockchain and talk about how we should move forward from where we are. So let's talk about the double spend problem. And this is not a problem that is at all new with blockchains. This is a very, very old problem in property law. So here's a problem that could have come up at any time in the past 1,000 years or so. It's a slight exaggeration, 900 maybe, but this is a very old problem in Anglo-American law. We have Alice who owns a piece of land, and in law school, the stereotypical name for a piece of land is Blackacre. It's like calling your variable X, it's just every piece of land is Blackacre, unless there's a reason for it to be something else. So she owns Blackacre, and she transfers the property to Bob. And the word we use in law would be conveys, which means to transfer ownership of a piece of property. It doesn't imply anything whether she sold it or gave it as a gift, just she transferred ownership to Bob. And then the next day she turns around and she transfers it to Carol. And obviously there's a kind of problem here in that Blackacre's one thing, you can't duplicate it. Bob and Carol can't both own it. So who owns Blackacre? Well, the rule of law traditionally been first in time, first in right. That earlier transactions have priority over later ones, which is a very straightforward and very intuitively sensible rule. And that once Alice has conveyed to Bob, she doesn't have anything left she can give to Carol. Bob is the owner of Blackacre, Alice has nothing, Carol takes nothing. So that's the approach that we would take in the abstract. But every legal system has to answer this with facts on the ground. And how do you decide whether this is what happened or whether that first transaction to Bob was a sham or never happened at all? Bob's in court saying, Alice gave this land to me. And Carol says, no, she didn't. Well, who's right? In 1250, so going back 750 years in English history, the way that you would do a land transaction is the seller and the buyer would both go onto the property, and the owner would technically make the buyer their new tenant, their fief, their vassal, by handing them a clod of dirt in a symbolic ceremony. They'd get some witnesses around, they'd all go home, and then later, if there's any dispute about the land title, you get the jury in, and you ask them, did Alice give Bob this ceremonial clod of dirt with the right circumstances? And the jury, who are people drawn from the neighborhood, will be asked whether they remember this ceremony, whether they've heard of it. And they'll say, yes, she gave him a clod of dirt. So it gets you an answer, but it's not very reliable. It's a distributed system that has this knowledge spread around a lot of people in a lot of places, and it keeps absolutely terrible records. No one is going to remember these details even 50 years later. It is just guaranteed to produce messes about the state of title. So Alice conveys to 1263 to Bob. Maybe she did, maybe she didn't, but by 1313, when Dave and Carol are now in a lawsuit over Blackacre, no one remembers what happened. No one was around then, no one can testify. You have no knowledge, and the system is simply not capable of producing reliable answers. So we have technology. We can solve problems through more advanced information technologies. And a great technology for this is paper. You write something down on paper, and then you put the piece of paper in a chest, and if anybody has any questions about it, you pull the paper out of the chest, and you look at it. So 400 years later, 1650, the state of the art is that the owner will give to the buyer by signing, sealing, and delivering a piece of paper called a deed. The deed is just a piece of paper that transfers ownership to property. Now, if Carol and Bob are in court, a jury is going to be asked whether Alice gave to Bob a properly signed and sealed deed. This is more reliable. That piece of paper is good for hundreds of years. We still have lots of deeds from this era in English legal history. They're still around. People could keep really good records. This is more reliable than the old system based on people's memories of transactions involving clods of dirt. But it's still far from perfect, because not only can these deeds be lost, but you can now start to pull off scams involving them. So Alice sells to Bob, and she hands him the requisite deed. And then Alice goes to Carol and says, would you like to buy Blackacre from me? And Carol says, sure, it's a great property. So Alice executes a second deed to Carol. And at this point, once Alice has Carol's money, Bob sews up with his deed and says, oh, look, this is earlier than Carol's deed, therefore I win. And then Bob secretly splits the money with Alice. And Carol is just out of luck and out of money. And this is actually really hard for Carol to detect. Back in the clod of dirt days, there'd be a public ceremony. The jury who would prove that this transaction had taken place were there to witness it. But you can sign, seal, and deliver a deed in secret. And it's just going to sit there like a submarine waiting to surface and take out somebody's land claims. So what the problem here is that we've gone from a system in which the records were too ambiguous to one in which they're not public enough to rely on. Back in 1250, it was mud, it was messy. You had fading memories and imperfect recollections of what actually happened. In 1650, you have more definite records, but they make stronger claims than they can back up. It's quite possible to have something that looks like an authoritative document that isn't, or that is and people don't know about. So a rule that the deed always wins is clearer than a rule about relying on people's memories. But it's also pretty clearly unfair in cases of secret hidden conveyances, like Alice to Bob in a back room. So we can fix this with technology. Paper's a good technology. What's another good piece of technology? An archive or an index. You go and you put all these pieces of paper in one place so that anyone who needs to check the records can do it. So in 1850, the act of conveyance is the same. The owner conveys to a buyer by signing, sealing, and delivering a deed. But there's a new step now. The buyer goes down to a recording office in their county, counties in the US at least, where we centralize this, and records the deed. That means you hand the deed to the person who works at the office, and they will bind the deed into a book and enter it in an index. So if there's a Bob versus Carol dispute over whether Alice validly conveyed the land to Bob, then someone will go down to the county records office, look in the index to find the Alice to Bob transaction, find the deed in the bound book, and inspect it, and come back and report, yes, this deed is there, it was recorded on such and such a date, this is a valid transaction. So we have a centralized system that now provides better publicly accessible records. And if you think about how searching for title in one of these systems looks, it has a really kind of cute similarity to how blockchains store data. So you bind the transactions in volumes by date. You start from the most recent transactions and search backwards until you find the transaction that the current owner claims they own under. That is, you search backwards until you find the deed from Alice to Bob. And then you go backwards before that. You want to make sure that Alice actually had valid title. So you search in the records to find the deed to Alice, and the deed from the person before that to the person who gave it to Alice, and so on. You go back as far as the records go, or to some legally denoted beginning of time, like 100 years ago. And then you search forward in the records to make sure there are no conflicting transfers, that there's nobody who, person who transferred to Alice didn't transfer to some third party before that. This is very much like checking the integrity of a blockchain. This is a backward check followed by forward sweep. So if we think of the land records as a blockchain, each volume is a block, the transaction history produces a chain of title, and you go back to the first block, which is wherever the records start. This is a process that is functionally similar because it's playing a similar role. So we have good records. Blockchain allows us to make these records perfect. We don't get recording clerks who drop your deed behind the radiator. The recording office doesn't burn down. Have we solved all problems for all time? No, we haven't. There are problems that come up with the recording system that are also going to be problems even if you make the recording system perfect. So this is a recurring pattern in the history of property law. It's not just about land records. It comes up in a lot of other areas. There's a desire for what Carol Rose calls crystals. These are clear, bright line rules like first in time, first in right. My deed is before yours, I win. Your later transaction is nothing. And there are lots of reasons to like crystals. They make litigation cheaper. Rather than having to ask dozens of people in the neighborhood whether Alice and Bob had the proper ceremony with a clod of dirt, you can just go and check records in one place. That means when it comes time to solve a dispute, the actual expenses of the lawsuit are lower. It also makes outcomes predictable. If you don't know how the case will come out because you can't survey 30 people in your neighborhood, you're rolling the dice when you go to court. If you know what the court will look at and you know what will conclude, that means you can predict how lawsuits will go, which means you'll settle them right up front. It also means that we know who owns what. We know that Alice owns Blackacre. We know that she sold it to Bob. We now know that Bob owns Blackacre. There's less ambiguity about who owns what. And as a result, we get easier transactions. If I'm going to sell you some land, I don't need to spend a long time convincing you that I really own it. The public records will provide pretty strong proof that I do. You can run and go check it yourself. And Carol Rose wrote this great article in 1988 called Crystals and Modern Property Law, in which she traces the same reasoning through a whole bunch of other examples in property law. She gives another example, which is the rise of mortgages. And lenders want to have a clear procedure they can follow to foreclose on the property if the borrower doesn't pay. So they're in search of a clear rule which says, if the borrower doesn't repay the loan, I can take the property and sell it to pay off the debt. This comes up not just in that area, but a whole bunch of places in property law. And she says, in a sense, hard-edged rules like these are what property is all about. If, as Jeremy Bentham said long ago, property is nothing but a basis of expectation, crystal rules are the very stuff of property. Their great advantage, or so it's commonly thought, is that they signal to all of us in clear and distinct language precisely what our obligations are and how we may take care of our interests. I know where I stand, and so does everyone else, and we can all strike bargains with each other if we want to stand somewhere else. I think that expression of clarity in legal relations should sound pretty familiar. But there's a problem, which is crystals have their own failure modes too. So here is a new, modern, post-recording act version of the land scam. The version in which Bob has a secret deed he doesn't record doesn't work because the unrecorded deed is invalid. But there's a different trick they can play. So now it's Carol who's the scammer, not Bob. Alice conveys to Bob, and Bob forgets to record. Well, then Carol comes in and says, I see you have some land. And Alice says, I sold it to Bob. And Carol says, don't worry about that. Just sell me whatever you own cheap. I'll pay you. And Alice says, sure, free money. You're buying nothing, but I'll sell it to you. Well, Carol conveys the land. And then Carol records the deed, at which point Carol has a recorded deed and Bob doesn't. So Carol can sue Bob and say, get off of my land, I'm the true owner. And Bob's out on his ear. He paid for Blackacre, but because he forgot to record, he owns nothing. Now, you could say Bob's a ninny. He really should have recorded. He didn't protect his interests. Then again, Bob is the person who is actually making use of the land, who is farming it, or doing whatever else one does with valuable land. Carol is not adding any value to the system. She's just looking for mistakes people have made and taking assets from them. She is basically black hat hacking the land recording system. She's taking advantage of Bob's foolishness, not adding any value. And when it comes to court, courts have been sympathetic to Bob, and so have the legislators who make the rules that all of this follows. Bob often wins in cases like this. And it's other scenarios too that are worth noting. So for example, Dave actually affirmatively goes out and looks for cases where the records include unrecorded grants, or conspires with Alice to say, here, sell to Bob. And then Eve comes in and records after Bob, before Bob records, but after he's done the search. Like, you enter her waiting around outside the recording office door. And when she sees Bob leaving, having done his search, that's when she goes in to record, which means she's going to win the race to record, and Bob will still be out on his ear. The result of this is that the pure race statutes in which the first person to record wins are only the law in 3 out of 50 states. In the other 47, there is some kind of notice requirement. If you buy land and you know that somebody else has a prior interest in it, you lose even if they haven't recorded. That rule foils at least 2 out of our 3 scammers. If you have actual notice of somebody else's interest, even if it's unrecorded, it's good against you. This has a major cost for the records, though. It means the records on paper aren't definitive anymore as to who owns what. It might be that there's an unrecorded interest that you would know about if you went out on the land and asked around. And what counts as notice is a new source of litigation, uncertainty, and expense. One of the things we do in a first-year property course is teach law students about the kinds of things that constitute notice. Like, there's a house on the land when the house is being occupied by somebody who's not the registered owner on the records. Or there's a common plan in the subdivision in which the other houses all seem to have a uniform architectural style, from which you ought to infer that they're all subject to a covenant that restricts the use of the land for residential purposes, and therefore you can't build your gas station on this corner. There are all these facts that are not going to show up in the property records themselves that you're just expected to know about and to pay attention to. This takes a lot of that purity of the recording system and chucks it out the window. As Rose says, the official records became an unimpeachable source of information about the status of land ownership. The law counts the record owner and only the record owner as the true owner. But, and here's where she explains why the law backs away from that crystalline clarity. This system was too crystalline to last. The characters to muck up this crystalline system by now should be sounding familiar. Ninnies, hard luck cases, and the occasional scoundrels who take advantage of them. So what this shows you in her argument in the paper is that property law is a balance between both crystals and mud. That mud by itself doesn't work. There's too much uncertainty. You need some clarity about property ownership. But pure crystals aren't really workable either. There's too many ways that they can go wrong. People get defrauded and people make mistakes. Property law sometimes bounces back and forth between the two. And even in systems that are more or less stable, you're going to find a mixture of crystals and mud. There are some bright line rules, but there are a lot of equitable and discretion-based and hard to nail down exceptions to them that will require detailed factual investigation. One metaphor I like to use is you can think it's like concrete. You need both the aggregate, the rocks, and you also need the cement to hold them together. You can't have either pure cement, it's not strong enough, but pure aggregate won't stick together, it'll collapse. You need both some hard crystals and some mud around them to make them graspable. So what does this have to do with blockchains? Well, let's explore some of the parallels. Blockchains are a really obvious win in some respects for replacing a recording system or supplementing one. The first point, if you digitize all of the records, it's easier to file and cheaper to search them. You don't need to go down to a county office and flip through a bunch of books and looking for documents. You're going to make fewer mistakes checking them because you can check them more easily. You're going to have better records that are cheaper to use and faster. And that's a win that you're going to get when you digitize them at all. If you just took the existing system and put all of the filing online, you would get a better system that was easier to use. You can do more. If you standardize the formats that you use, you can make it computationally tractable to search. Instead of needing to flip through thousands of idiosyncratic documents, every different variation on a form that lawyers have used to transfer ownership, you can have a few standard transactions whose consequences are easy to follow through. This document transfers ownership of these identifiable assets. You chase those through. A computer can go ahead and do a lot of the searching for you. It can produce a complete report on the ownership of particular assets. And some of the really advanced tools that scan and trace the process of Bitcoins through mixinets. You can do lots of neat things with this that are demonstrated in the blockchain context once you have standardization. And the third thing, again, that's standardization. You can do it with any good digital format. The third thing that really distinguishes the blockchains is the decentralization. You don't have to trust the clerks in the recording office. People who were dropping deeds behind the radiator in the old days might also mess up digital filings in some respects, or you might not trust them to keep the servers well maintained. You might not trust them to intervene and forge documents in the history if they got bribed. If you have a distributed system like a blockchain, you might believe that you can make it more reliable with fewer single points of failure in a government office. So a peer-to-peer maintained system of records could be superior in terms of not having a single point of failure. So should we put titles on blockchains? Well, there's the obvious case is that a lot of problems go away. You have fewer ways in which they can fail by mistake. You have a system that's less expensive in a lot of ways. You have something that is going to use the things that computers are good at. But a lot of the other problems that I've been thinking about and talking about here don't go away just because you digitize the records. So there's a great example that I got from Armin Narayan in thinking about blockchains, which is that you can't really have perfect title documents because the documents can be more perfect than the world they purport to describe. So you can use a car title, pieces of paper that you write down who owns the car on and transfer to the person. That paper document simplifies car sales. It helps to be able to take the title, write the buyer's name on it, hand it to them, and then they can go re-register it. That helps a lot with simplifying car sales, but they can't be conclusive. Well, for one thing, people can steal cars. So if you steal a car, then I have this title document that refers to a car I can't actually give you. So selling the document by itself is useless. On the other hand, if I steal your car title, then I could purport to sell it to somebody and then just not deliver the car. So one way of thinking about this is that the document and the physical thing can get out of sync. And it's not just theft. It can also be just mistakes. If I have a car business and I hand over a physical title to the wrong car when I'm selling you a car, well, now we have a mismatch between the documents on paper and the records in the physical world and the physical thing. You can have cars that get wrecked. You can have people losing documents. You're going to have a system in which there's this slippage between the document and the thing. And even if the system for handling documents is near perfect, you are still going to have problems on the side of the thing. In real property, for example, law of adverse possession says if I'm on this land for a set amount of time, 7 years or 20 years, whatever it is in your state, then I become the owner because the law's perspective is, well, the facts on the ground are that I am there, I'm acting like an owner. Whatever else the law thought the ownership state was no longer in sync with reality. Let's go with reality. That's going to happen no matter how good your titling system is. And there are other risks that lawyers would call off record, things that you can't perceive just by looking in the records. So in land and real property, one such source is transfers where you didn't record. You need to record to make a sale valid against subsequent purchasers, but gifts or property that passes by will or transfers in bankruptcy, all those happen, we'd say, by operation of law, and they can happen with no recordation. If you are using a digital system to manage asset titles, somebody could steal the private keys you need to send transactions. Private keys get stolen and lost all the time in the blockchain world. You can also have various species of fraud. So you can have what lawyers would call fraud in the factum, where you get tricked into signing something that's other than it was held out to be. Like a website says, click here to agree to the terms of service, and actually it goes ahead and you've just agreed to have your credit card billed. Or you could have fraud in the inducement, which is, here, you sign this document and give me title to this thing, and I will pay you $1 million. And then they never come through with a check. Law attaches different consequences to different kinds of transfers, but all of them involve cases in which the person who was the owner has some right to get the thing back, or there's a transfer that's not going to be reflected in the records. If you're dealing in property, whether it be a house or an expensive watch or a car, you are going to have to think about the possibility that one of these things could be going on, regardless of what the records tell you. And you would still need to think about these possibilities, even if the records were completely perfect. So one way of thinking about this is that blockchains are crystals. They are really, really good about protecting against errors on the blockchain itself. If you satisfy certain properties, you can be pretty confident that the records on the blockchain are correct. You are not going to get dropped digits in a blockchain transaction. But the blockchain by itself is not going to help you much against errors off the blockchain, and you'll need some kind of mud layer to deal with it. So I promised thoughts about where to go from here and how the system can, at a general layer level, respond to these kinds of tensions. So one solution would be what I call legal imperialism. The law should just say, look, blockchain assets are property. That part, at least, is pretty unmistakable, I think. They are kind of property that is intangible, you can't touch it or hold it, but it's real nonetheless. Blockchain assets like Bitcoins are as real as domain names, and those can be bought and sold too. So courts can order property transferred. Smart contracts are legal contracts, so courts can step into them. These have real legal consequences. Maybe courts should just take control. Maybe courts might say, well, you seem to be the owner of those Bitcoins, but those were given to you in a fraudulent transaction. You need to pay them back. Or, yes, the smart contract gave you those assets, but you misled the person you were dealing with about what the smart contract said. You need to return those. This might work as a matter of legal doctrine, but it has really big obstacles in the real world. The first problem is that blockchain users might not cooperate. Now, if you're sitting in the jurisdiction of a court, if you have been sued in the Federal District Court for the District of New Jersey, you're in New Jersey, like the US Marshals can come along and enforce the court's judgment. They are going to make sure that you listen to what the court says. But what if you say, I don't remember my private key, I lost it? Or what if you say, nope, I'm not going along with this? Or more reliably, what if you are not in New Jersey? What if you are in Mauritius or Belarus? The district court here can't touch you. It has no good way of forcing you to use your private key to make a transfer. This leads to a real problem about making the person. Might even be a person the court can't identify. If you're dealing with people only online, the court's going to have a real problem making its judgment stick. Okay, what about having court that says, we'll go to the people who run the blockchain, make them rewrite it? Like, you can laugh at that one, and rightly so, because the collectivity of blockchain miners is unlikely to cooperate as a group. You might get a few who are in the court's jurisdiction, who even if the legal system decided it could issue orders against them, they won't suffice to change what the blockchain says. The larger volume of miners who are out of the court's jurisdiction will go on recognizing what they see as the authoritative blockchain. It will continue to reflect their view of reality. The court just doesn't have power to rewrite the chain. A worldwide community is really resistant to the power of a single jurisdiction. Okay, let's go to the other extreme. How about blockchain purism? This is the standard crypto dream of autonomy from the legal system. Whatever the chain says goes. That is the state of reality. That confirms who has assets on the chain and who owns them. And any law to the contrary just does not matter. You can't order users or miners to do something other than what the chain says. And this creates a certain kind of system for blockchain users that should be pretty familiar from lots and lots of security papers. They call it caveat user. It's your job to keep your private keys secure because if you lose them, we won't help you. It's your job to read any smart contracts you enter into carefully because if they do something you didn't expect, that's on you. Don't pay in cryptocurrency for off-chain goods until you've had them delivered. If you ignore these rules, that's on you. It's on you to keep yourself safe. I don't think this is entirely realistic an ask of the legal system. One reason is the same reason we have mud and not just crystals. Ninnies, hard luck cases, and scoundrels are probably not going to go away. I think the blockchain community is a pretty good example that even people who are deeply into this technology have plenty of all three. So the argument that people are going to make when they feel like they've been robbed of their property is they're going to go to the legal system and say, can you set things right? Now, sometimes nothing will be doable. Nothing can happen because the people who took your Bitcoin are unidentifiable and out of the country. But there will be times when the other parties are identifiable, the court can get its hands on them and will say, set things right, give them back their Bitcoin. And it's going to be very hard to say that, oh, I don't need to give you your Bitcoin back because Bitcoin is a fraud-free zone. You paid in Bitcoin, you took the risk, I was lying to you. That's not the kind of excuse a court's going to be inclined to listen to. Still going to be a crime if you convince your victims to pay you in Bitcoin. There's also, I think, a deeper problem with trying to declare the blockchain independent, which is that it's not clear that users really want complete autonomy from the legal system. So you think about all of the credit card, all of the payment systems we use today. There's a pretty huge diversity of them, from credit and debit cards, personal checks. We have apps like Venmo. We've got a wide range of these systems. And a lot of them have really extensive protections built into them. By regulation and by contract, you have a lot of rights against losses that come from within the system. If you buy something from a merchant and the merchant doesn't ship you the goods, your credit card company will credit you back and they will pursue the merchant to make good on it. If your card gets stolen and you promptly report the loss, your liability is capped by regulation. You don't bear any liability for purchases that were made by somebody pretending to be you. Somebody just recently, this week, tried to purchase $19,000 in jewelry from a Jared with my credit card. They had the correct number. Well, I called the credit card company and I called the Jared, and within 30 minutes, I'd been assured by both of them that I wasn't going to bear any responsibility and this was not my problem. I'm just glad this was not credentials for cryptocurrency. But that's also why I'm comfortable using a credit card to make purchases. So what protections that come with them make them safe for everyday use. Now, there are payment systems that come with fewer protections. So the wire transfer system, which is heavily used by large commercial entities to make large payments, is much more, I don't say, much more living close to the edge. It's very hard to unwind a wire transfer from a party who doesn't want to give it back if they've already taken the money out of their financial institution. But because of this, businesses tend to be extremely careful with their credentials for this. They have pretty careful security protocols with their financial institutions over who is allowed to authorize them and how. And the procedures they use internally to authorize them require double checking and frequently a second pair of eyes on every transaction you make, precisely because they're so risky. But this is something you can use for occasional large transfers. It's not something that it's a level of precaution that you want to use when you're buying a cup of coffee. So from that perspective, the point is that the legal backdrop makes it safe to use the payment system widely. And the legal backdrop makes the credit card system much less pure, but also makes it much more attractive for end users. Here's another example where the impurity of mud makes a system more attractive to people who use it. So secured lending. If you sell cars or boats or if you have a restaurant, you typically are doing so on credit. You have lenders who have given you a line of credit or have given you a loan, and their loan is secured not just by your promise to pay them back, but by a bunch of your assets. Restaurant, the tables and the food in your kitchen freezer, and even the cash in your cash register are all probably subject to a lien in favor of your lender. Your inventory, your accounts. And this matters because if your business goes under, the secured creditor is first in line. They get to pick the assets that they had a lien on and just walk off with them. All of your general creditors, your employees, people you borrowed money from who you didn't give a specific lien to, they all get in line and they divide whatever's left after the secured creditors take their collateral and go home. This makes secured lending more attractive, and it makes people more willing to advance these kinds of loans to businesses. And businesses pretty universally rely on this kind of credit. Well, one reason that lenders are willing to do this is that liens trace into what are called proceeds. If I'm a boat dealer and I sell a boat, the consumer will give me a check. Now, the lender had a lien on the boat. They probably actually even had the boat's identification number listed on documents that listed the collateral. The instant that that boat leaves the lot, they no longer have an effective lien on it. It's in the hands of the purchaser. They can't go after the buyer to get the boat back. What they can do is they can get the check the instant I get it without needing to go and specifically identify the check and the amount and the number on it. They just have a lien on that thing as proceeds of the boat sale. Well, I think the people who lend to businesses would be pretty unhappy if you told them that, sorry, you don't get a lien in crypto assets. If the customer pays in Bitcoin, sorry, you can't collect that. That's not part of the legal system. I would think the response of most lenders would be to say, well then, we forbid you, our borrower, from taking payment in Bitcoin. If you're going to take this payment system, it has to be something that we feel comfortable being able to legally trace our lien into and being comfortable being able to collect and foreclose on if we have to, if you get into distress. So there's going to be pressure to make sure that these crypto assets are subject to familiar property rules. So the point here is that people who use the banking and payment system actually like some of the mud in the current system. They like some of the ways in which the clear on paper records are muddied up by other documents that are harder to check in the system itself. It protects them from cases that they are scared about, in which things go wrong and they're on the hook for a lot of money. And because they feel protected against those downsides, they are willing to engage in valuable transactions. A system that is too clear, too crystalline, is dangerous because it can really cut you. Uncoated crystals are sharp and cut. People will avoid systems in which they feel they have too much at stake and too much at risk they can't manage through reasonable everyday precautions. So what do we actually see in cryptocurrencies and blockchain-based systems that have achieved wider adoption? Incredibly heavy use of intermediaries. The blockchain is the blockchain. It exists in all of its purity, in all of its distributed perfection. But people interact with it through exchanges and escrows and payment processes and wallets and all these other surrounding infrastructure that isn't just a blockchain. And these aren't just user interface conveniences. It's not just that you have a nice convenient website you can use rather than having to run your own software. They also protect people against mistakes. They can spot fraud as it happens. They are subject to legal process where the assets can be frozen if necessary. They look a lot more like the existing banking and payment system than like the blockchain in some respects. And that means that it's safer to use them. You actually have a feeling that you can go in and deal with the blockchain with more confidence that you're not risking losing everything you have connected to it. So they muck up the purity of the blockchain system. And we have plenty of examples of them engaging in fraud, mismanagement, and waste of their own. And yet people still use them. They complicate asset ownership on the blockchain. It's not just who controls the private key for this asset. It's also now who is subject to a garnishment order that's been served on a crypto exchange. But this mud is necessary to make the blockchain usable by mere mortals. It brings people into the system who would not be able to participate otherwise, and the mud is an essential condition of their participation. So you can do the same thing about smart contracts. They securely transfer assets under certain conditions, but the smart contract is not going to be able to confirm that a concrete foundation for a house has been properly poured. I do not think there's a set of sensors you can embed in any real-world IoT setting that will be able to verify the absence of defects in house construction. There are lots of cases here where you would like to write contracts around various conditions that you will never be able to measure automatically. And most of the complexity in actual contracts is an attempt to deal with the complex things that can go wrong in real life. If you look at the legal provisions of an agreement, I don't know, 80% of a standard complex contract is dealing with what happens if these various kinds of real-world events trigger. You look over the last few months, a lot of this is in litigation over what happens if there's a global pandemic. Well, that's the kind of contingency contract drafters trying to plan for. That is not anything inherent to the system itself. This is not the kind of clause that you really need in your smart contract. It's about thinking about states of the world that exist outside of the blockchain. So oracles are a kind of mud. They are an interface between the crystalline world of the blockchain and the muddy physical world, and they're necessary to make the two of them able to work together. So to wrap up, I think of Bitcoin and other blockchains as crystals in a world of mud. There's very little harm in having an alternative to existing banking and payment systems. They don't make things worse in terms of the problems that Carol Rose has described. But the problems that they're solving are mostly not the ones that blockchain, property and commercial law have spent centuries worrying about. Yes, there are some issues involving mistakes in the recording system. But for the most part, the kinds of things that I teach my students when I teach first-year property are not the kinds of problems that any kind of perfect titling system will ever solve. There are so many other things that can go wrong and or cause conflict in how people use property. You won't be able to fix it or deal with it using a blockchain. People are never going to be as perfect as the blockchains they use to interact. So there are lots of places for cryptocurrencies and blockchains to improve on these systems. It would take incredibly large changes to society to supplant existing systems, but there are lots of great ways to hybridize them. So my general encouragement, those of you thinking about how do blockchains interact with the rest of the world, is try to avoid the sweeping claims. And I'm sure you know tons of Medium essays that engage in this kind of claim. Instead, think about precise use cases. Think about somebody who wants to engage in a particular kind of transaction and walk through what are the steps they currently have to do, what does the legal system say about those steps, and how, if any, can those steps change if you have a blockchain available as a way to communicate, to share information, to record things. In some cases, you'll find nice tweaks that shave off problems. In other cases, basically the system is adapted to the current problems that won't change much. And my final meta piece of suggestion is, like, talk to us lawyers. Most of us don't bite. I am here because I think that law and computer science have an enormous amount to say to each other. And I want to help those conversations. And part of this is teaching people who build technologies about why the law does what it does. And part of it's teaching people on the law side about why people are building these things and what problems they're trying to solve. And that translation has to go both ways. We all have a lot to learn from each other. Okay, so let's take this over to discussion, and I'll take off my slides. Interested to hear what you had to say.
Thank you, James. That was a really interesting topic. I have one sort of question comment to start it off. So when you were talking about providing legal protections for things that happen in cryptocurrencies, I was thinking about the privacy that is not perfect, but is often discussed as one of the sort of big positive impacts that Bitcoin has on users. I was wondering what you think the balance is there, where you could provide adequate legal protections, but users might still have some privacy.
That's a great question. And building privacy protections in is one of these really interesting places where there's a lot of fruitful technical ferment over existing systems. Because right now you have systems that are basically, here's a database, and all the transactions in it are basically available to anybody who has authorized control. And we just try to build firewalls about who has access to the database. But there are lots more combinations you can work out with blockchains or other technological primitives, and really interesting ways that make certain information available under certain circumstances and not other information. And I think it's a great area. And one of the great questions to think about, pose on this is, you ask, what do we really care about and why? It's not just, oh, this is the balance existing law strikes in terms of who can see which transactions and what they can learn about them. But you could actually ask from first principles, okay, what information do we have to expose in order to facilitate anti-money laundering analysis? What do we have to expose in order to enable proper asset seizures when people are having their assets attached to pay debts? How can we make only those or make only authorized analyses available while keeping other information private? So we have fewer people we have to trust in the system. How can we do this while making it compatible with the distributed system? I think those are great questions. Law is one source of input into them, but we shouldn't by any means take existing law as the be all or end all of what the privacy rules have to be. It may be that with these technologies, we can achieve better, more nuanced trade-offs that we weren't available before. I have a great question from Eswar Prasad. Is the problem you described, the title and object not being in sync, relevant only for physical objects, delivery versus payment, related to a blockchain, where the object being traded is purely digital itself, exempt from this problem? That's a really good question. And the answer is, for some kinds of digital assets, yes, and some kinds of digital assets, no. So I would say the distinction I would make would be, is the thing blockchain native? Or is it native to the digital system? Because you can have digital systems in which the system is authoritative as to who controls it. So the domain name system is a nice example of a non-blockchain system that's basically authoritative as to who controls a domain name. The records are managed through an authoritative central registry. Each domain name is managed through a single identified registrar, and they have authoritative records as to who controls it. You can have a legal system come in and try to say, nope, you don't actually control this domain name, you defrauded arrangement, you need to give it back. We have the UDRP for transferring domain names when there are trademark infringements. But there's no dispute as to who actually controls it. That is, there's basically never a situation in which people both think, I actually own this domain name and I'm actually controlling where its records point right now. That doesn't happen because systems are architected to prevent that. The same thing's true for blockchain native property. You can have atomicity where the transaction and the payment and the control title are locked together, which is your basic smart contract use case. So for some digital assets, yes, you actually don't have that risk of getting out of sync because the blockchain itself controls who owns it. For other kinds of assets, especially informational ones or digital media, it's much harder to enforce. So you could have cases where ownership of music, for example, or a licensing system could get out of sync. If you have a DRM failure or a client fails to enforce use restrictions, or somebody records it, you can have situations in which it's not clear whether the fact that I am licensed to do this for X time really corresponds to what I'm practically capable of doing or not. So it varies a lot by the kind of property. If you have something like a financial security, your example, then it's going to depend upon how tightly integrated the records are with the blockchain that purports to trade them. If it's an external system, then the external system and the blockchain that says, here, I have title to this thing, could be out of sync because the other system can get hacked. You have to really ask, does the blockchain itself speak authoritatively about ownership?
Yeah, I've got a question. In your opinion, where does the liability lie when there is actually a problem in, say, an oracle itself? So an oracle promises to bring some of the some of the off-chain data on the chain for some smart contract to process, but then there's the bug maybe in the oracle code itself, and the oracle, consists of two different parts. One is the actual writing stuff on the chain, and the other one is basically pulling the data from the real world. Is there some legal stances on that for liability for these kind of services?
It's really complicated. There are a lot of different bodies of law that I could see getting involved with that. I mean, you'd look first to contract law to see if anybody has made legally enforceable promises. And typically, I wouldn't think that an oracle or people providing it would have written a legal contract separate than the smart contract saying, we promise to deliver this level of service or we promise nothing. Of course, it's quite possible that a court might try to use the fact of the structure of the oracle itself or the smart contract that connects it to the blockchain to imply that there is a legal contract. So there's been some very good work recently from J.G. Allen and from Dave Hoffman about cases under which a smart contract might imply legal obligations. But even if you didn't have that, a court might also look to try to find some kind of negligence standard that you had a duty to provide this information reasonably. And if you didn't take reasonable precautions, then you're responsible for it. There's an argument you could apply products liability law, although I think most courts would be very resistant to that for a service like an oracle. There's a real hole here. It's a hard problem to start with, finding liability for defective software. And in the blockchain, it's an especially complex situation because you have so many interacting parties. In the commercial software world, the absence of law is largely because companies are so good at using disclaimers of liability. They say, look, we provide no promises, the software is provided on an as-is basis with no warranties at all. The blockchain actually makes it harder to provide those waivers. You have less guarantee that somebody who is interacting with your software or your service has had to click through or agree to your purported waiver. So it may be harder to disclaim other sources of liability. But the short version is there are a lot of possible answers and very, very little law that supplied answers to them.
I was wondering, so in a blockchain system where basically once something is on the chain, the transaction cannot be undone, what would legal payment protections look like? So would it have to be, an equivalent transaction to reverse it, or is there another way around that?
I think a lot of it depends upon what your model for the virtual machine implemented on top of the blockchain is. Because you could always define a virtual machine in which a properly authenticated transaction could simply reverse an existing one. And that would allow you to do repayment. At that point, the question would be which transactions get this special previous transaction reversing power, because obviously I shouldn't be able to just reverse my payment to somebody 2 days later. So you could always define a virtual machine or smart contract in which some specified party has the ability to come in and enter later transactions or revisions to existing ones that some ways alter their effects or undo them. And the design question is very much, how do you do that in a way that doesn't undermine the certainty the blockchain promises to provide you? This is a question that Ari has thought about in the escape hatch work.
Well, if there are no additional questions, you've actually run exactly on time. So thank you so much for presenting, James. That was a really interesting topic.
Thank you. And thank you all for coming in today.